Good afternoon and welcome to the first of Legal Aid Alberta's webinar series in celebration of our 50th anniversary. My name is Wyatt Fraser and I'm Legal Aid Alberta's engagement facilitator. Thank you for joining for today's webinar, Youth in Crime, What Parents Need to Know. Youth in Alberta are guaranteed free legal representation in criminal matters, and Legal Aid Alberta is a leader in this field of law. In 2022 to 2023, Legal Aid Alberta staff and roster lawyers in private practice handled over 3,500 youth criminal cases. This webinar will provide key information about the youth criminal justice system for parents and teens and give hints on what to do when kids get involved in the justice system. In a democracy, the principles of justice and the protection of legal rights are the cornerstone upon which society is built. These principles remind us that every individual deserves equal protection under the law, regardless of their circumstances. At Legal Aid Alberta, this belief is not just a sentiment, it's the very purpose that drives us. Helping to ensure an effective, efficient, and balanced justice system since 1973, our dedicated team of lawyers, frontline workers, and administrative professionals strive to not only protect the rights of disadvantaged Albertans, but ensure their individual voices are heard. Through our work, we provide solutions to promote and enhance not only our clients' well-being, but that of our communities as well. Legal Aid Alberta represents approximately 35,000 Albertans at any given time, spanning 75 communities across the province. Additionally, our Justice of the Peace Bail program conducts approximately 30,000 bail hearings annually, and our lawyers help apply for over 2,000 emergency protection orders each year to safeguard those facing domestic violence. Duty counsel lawyers serve countless thousands of Albertans every year by providing free legal advice to those appearing in court for their first time. Public education is a key priority for us. As mentioned, this webinar is being recorded and will be made available on our website later this week. By default, your microphones and cameras are disabled, so you're able to focus on our speakers today, but you can engage with us using the Q&A feature in Teams. As a reminder, this session is not intended as a forum to obtain specific legal advice, but rather aims to educate about general legal processes and Legal Aid Alberta services. To ask a question, you can click the Q&A button at the top of your Teams window, enter your question in the dialog box, and click Post. We will leave time at the end for questions, and we'll get through as many questions as we have time for today. We're also going to share a link at the end of today's session for all attendees to complete an anonymous survey, as we'd love to hear your feedback about today's session, as well as suggestions for other topics that you may be interested in learning about. In the spirit of reconciliation with Indigenous, First Nations, Métis, and Inuit peoples in Canada, Legal Aid Alberta makes a solemn pledge to work towards positive change in the legal system for fair representation with consideration of their unique and historical situations. We respectfully acknowledge that we are situated on the ancestral and traditional territory and travel routes of many peoples, including those on the land of Treaties 4, 6, 7, 8, and 10, the Blackfoot Confederacy, Kainai, Bikini Siksika, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, Cree, Tsuut'ina Nation, and the Métis people of Alberta. We recognize the challenges faced by our Indigenous, First Nations, Métis, and Inuit clients involved in the justice system. We commit to meaningfully respond to the Truth and Reconciliation call to action and the missing and murdered Indigenous women and girls call for justice. To do this, we strive for action and accountability through our Indigenous Action Plan. This plan aims to continuously engage with these communities to better develop relationships, opportunities, programs, and practices to serve our clients. At Legal Aid, we're committed to providing education for management and staff on the history of Indigenous peoples. We are working to establish panels of lawyers trained on the history of Indigenous, First Nations, Métis, and Inuit clients and communities, and consideration of the history under the laws of Canada. We are participants and dedicated members of the Indigenous courts in Alberta. In an act of reconciliation and gratitude, we acknowledge all Indigenous, First Nations, Métis, and Inuit peoples who have lived in and cared for these lands for generations. We express our continued thanks to be able to work on these lands and represent Albertans in this territory. And it's now my pleasure to introduce our speakers for today, Karen McGowan and Kathleen Reyes. And with that, I'll turn it over to you guys.
Thanks, Wyatt. So today's presentation is going to be about what to do when your teens are acting out. The quote here is that sometimes parents have tried everything as a parent, but the youth criminal justice system is not parenting. And you should know that once a charge is laid, your child's fate is no longer in your own hands. So the agenda today is going to be about the youth risk factors, when it's necessary to call a lawyer, and what the youth rights and legal options are. Myself, I have specialized in youth criminal law for 24 years, and my colleague down south in Calgary is Kathleen Reyes, and she is specialized in youth criminal law for 17 years. So let's talk about teens in trouble, and I will turn it over to Kathleen to discuss the risk factors that are common to youth.
So the risk factors you see on the screen right now are not necessarily a checklist of what to look for teens that are likely to be in trouble or not. These are just things that over the course of our years of practice, we have observed as being present in youth clients. So a large majority of our clientele in the past and in the present have come from Indigenous nations. Some of our clients have been victims of abuse, either sexual or domestic. And beyond the legal factors, many of our young persons coming into our courts face more than just criminal charges and come from areas of the social fabric that gaps may have arisen in their background, such as not having a stable place to live, having undiagnosed cognitive or mental health issues, um, in addition to the more commonly known or assumptions regarding risk factors, including peers that perhaps parents don't want their teenagers to hang out with, uh, teenagers getting introduced to illicit substances, and teenagers just generally being bored. The risk factors themselves are not a exhaustive list, but they do clue us into asking further questions beyond just what the legal issue a client is facing when they come into our court system.
Thanks, Kathleen. Um, so a lot of people here might be thinking, well, not my child. My child is a good child. So while most crimes are committed by teens with certain risk factors, as Kathleen had mentioned, they don't always fit the same mold. Some teens who find themselves in criminal court do come from more ideal socioeconomic backgrounds. Typically, they are what I would call the one-hit wonders whose brush with the law was enough for them to stop. Example, getting caught for shoplifting. But some criminal offenses know no socioeconomic backgrounds. And in my experience, it is more common among affluent teens to be engaged in such things as child pornography and sexual assault.
A lot of times when teenagers do get into trouble with the law, that is when parents will think about what they can do to scare their teenagers straight and will often turn to the police to try to assist in helping them guide their teenager towards making more positive decisions. Um, Unfortunately, it's not always simple as engaging officers to give a hard talk to your teenager. Often involving the police can turn into something much more than what parents may expect, even when liaising with law enforcement officials. Uh, for those parents who might turn to the justice system and think this is the way to add to how I will parent my child, they often find themselves facing newer issues uh, and find that the justice system may sometimes take out some of the decisions that they would normally make as parents and take them out of their control. So knowing in advance as to what you're actually looking for and what the police are being called for can assist. Because once the police are called and they take control of a matter, the parent's role in terms of directing what happens next becomes much more limited.
Hmm. So a lot of parents think that their teen can learn a lesson or two if they spend a night in jail. But that's not going to scare your child straight. In fact, what might actually end up happening is that they end up making friends with the negative peers in there, and now they have new criminal associates. Sometimes parents are told either by children's services or the police that having their child arrested is the only way to get a psychological assessment done to find out what's going on with them. But you should know that what we call Section 34s, they're only ordered for more serious offenders and in very restricted circumstances. The Youth Criminal Justice Act has very strict parameters of when they can be ordered. So typically your first time offender is never going to be getting a psychological assessment. That is something that the parent's going to have to do either through health services or by going to children's services and asking for their assistance. So let's talk a little bit about the police interviews. So a parent might get a phone call from a police officer asking them to come in for an interview. And parents or guardians are going to wonder, well, how can they help their child? Well, the best thing that you can do to help your child is by protecting their rights and supporting them through the process. Sometimes the police will insist that they want to interview the young person, and it's up to the parent to bring the child in. It's very important to speak to the police officer and make it clear whether or not it's that they're coming in for an interview or if the intention is to arrest them. If the intention is for an interview, then you should be declining the interview. Anything your son or daughter says can be used against them in court and may actually build the case that they didn't otherwise have. Um, so yes, be aware that if a teen speaks to the police, this may actually provide the police with what they needed to prosecute your teen. In my experience, when police want to speak to the young person, that's because the evidence that they have is very weak and they need some kind of confirmation, and that's why they have the young person come in. If, however, the police make it clear that they want to arrest the young person, then yes, you need to take the young person in because either the police do it the easy way or they do it the hard way. And the hard way, obviously, is coming to arrest your teen, putting them in handcuffs and dragging them off. So if the police are seeking to interview your teen, please call a lawyer. Legal aid staff lawyers will provide advice to you and your teen. If you call during business hours, and we'll show the 1866 number in a moment, they can get advice anytime. If the young person is calling after hours, typically this is going to happen while they are in police cells. And there is a different number that goes to our on-call lawyers. So before you go in, please call this number, which is 1-866-845-3425. They can put you in touch with one of our staff lawyers that specialize in youth law, and we can speak to them during the business hours. This is also the number to call to apply for a lawyer once the young person gets charged. So now that you're at the police station, because the right to speak to and have a parent and or lawyer present during an interview, that is the child's right, not yours. So you will have to ensure that your teen knows to ask for you and a lawyer. The police will separate the teen from yourself, and the young person will be given a 4-page form which explains their rights. Make sure that your teen knows to always tick the boxes for yes, I want a parent, and yes, I want a lawyer. And even if you even spoke to a lawyer before going to the police station, please call again when you arrive. Sometimes situations change, sometimes the charges are different, or sometimes you have just forgotten everything that the lawyer told you the day or a couple days beforehand. And again, Legal Aid has a free 24-hour on-call service staffed by our lawyers who are individuals with extensive experience in youth criminal justice.
Flowing through that situation where your teenager's at the police station and you've called a lawyer, just a heads up that unlike adults, young persons can call as many times as they need to when things get confusing. Some kids may get concerned that on television or on the movies, they see adults with only one phone call. That is not the case for young persons. Uh, once a young person has been arrested and charged, uh, the issue of their release then becomes the next concern. Uh, there is always a right to a bail hearing within a certain time period, and usually that's within the first 24 hours of being arrested. Um, like our on-call uh, advice service, where staff lawyers provide information and advice to young persons under arrest. We also offer duty counsel services for those persons seeking bail. So if a young person is not released by police officers on their own with conditions, there will always be a duty counselor from Legal Aid Alberta who will contact your teenager waiting for a bail hearing to get more information and try to get them out of jail with a future court date in mind. Um, it is not a quick process. There's often a waiting period in place for that teenager to wait for that bail hearing to occur. Uh, Reminding your teenager that if they're waiting for a bail hearing, still do not answer any questions or any statements for the police, because that won't make it happen any sooner, is always helpful if you are present there with your son or daughter. Otherwise, hang tight until your bail hearing happens. If it doesn't happen at the JP bail stage, then there's always opportunity for a bail hearing in the provincial court system as well. Oh, Karen, I think you're on mute.
Thank you, Kathleen.
You're welcome.
So even if you get bail, you'll be given a court date. And if you didn't get bail at the JP stage, then yes, there'll be another opportunity the next day in court. So if your teen is released on something called an appearance notice, there should be two dates on there. One is for fingerprints and the other is for the court date. The first date is the fingerprints, the second date is the court date. Your youth needs to attend for both. If you miss either the fingerprints or the court date, there will be a warrant for the young person's arrest, and that's not something anybody wants to happen. You don't need to do anything else before court. Simply proceed to youth court and look for duty counsel who will help your teen navigate their options. Sometimes it's not necessary to actually apply for a lawyer. Some young people may be offered something called extrajudicial sanctions. And this might occur for first-time offenders, for things like mischief to property, simple assaults, and thefts. Extrajudicial sanctions is a program that allows young people to have some kind of consequences. It may be doing some community service hours, it may be an apology letter, it could be a poster, it could be any number of things. But if they do those things, then the charge gets withdrawn, which means the young person would not have a criminal record. So that's why you don't need to call a lawyer. Now, if there is a legal defense, perhaps the young person was wrong place, wrong time, or they had a positive defense like self-defense, or isn't otherwise eligible for this extrajudicial sanctions program, duty counsel can then refer the young person to legal aid and adjourn their youth matter for the appointment of counsel. So again, if your young person has already made it through the bail process, has a court date, you don't need to hire a lawyer ahead of time. Speak to duty counsel, because our duty counsel lawyers are also very experienced in all youth matters and they can help you navigate the system.
If you are going to be getting a lawyer, there are different ways to do so. One is to hire a criminal defense lawyer, ideally one specializing in youth criminal defense. Legal Aid Alberta has in-house staff lawyers such as Karen and myself that have practiced in youth criminal defense for a number of years. There is also a list of roster lawyers that have been pre-screened that have built their experience in youth criminal defense law that Legal Aid can also make referrals to as well. The application process is fairly simple. There's information on the website, which is linked below and is on the slide. Our services for lawyers through Legal Aid are not free, but it is much, much, much lower than most private retainers. And Legal Aid's always focused upon making sure young persons have access to counsel. And so there is flexibility in various ways to pay for counsel once the matters are concluded. Once a lawyer has been assigned, you'll find that your son or daughter will be meeting with that lawyer and getting an idea as to what it actually means to deal with their criminal offenses, including learning about what the lawyer-client relationship actually means, what it means for the lawyer to be that your child's lawyer in court, and also be information for you in terms of how much information the lawyer may be able to share with you as part of those initial meetings. Uh, there are things that need to be kept confidential between our clients and the lawyer themselves. There's also the concern on a lawyer's part of making sure that parents or guardians aren't inadvertently becoming witnesses to information that our client may provide to us. And so explaining the details of what lawyer-client privilege is something that the lawyer will do with your son or daughter and with yourself to answer any questions that you may have in terms of how much information is going to be shared.
You'll see on the slide that we also talk about, apart from the whole solicitor-client privilege thing, my experience has been in the past that if the parent is not present, the young person is more forthright and honest with the lawyer. And sometimes having the parent present often inhibits that honesty for fear of judgment or punishment from the parent later. So there's kind of two reasons why you might not want to be present when the lawyer is speaking with your child. All right, so let's talk about youth criminal records. There is this myth out there that once you turn 18, your criminal record magically disappears and you get a clean slate. That is not the case. So the Youth Criminal Justice Act is actually designed to rehabilitate and reintegrate young people to become contributing members of society. That is the primary purpose, apart from, protecting the public. As long as a young person completes their sentence without incurring any new charges, the record will be sealed or destroyed after 3 years from the completion of the sentence in the case of summary offenses and 5 years from indictable. So the difference between summary conviction and indictable offenses is kind of akin to the American version where you've heard words like misdemeanors and felonies. So summary offenses are the Canadian version of misdemeanors, and the indictable offenses is akin to the felonies. Now, if a young person does commit a criminal offense within that access period and after their 18th birthday, that youth record then becomes permanent and will not be sealed or destroyed without actually applying for a pardon. Um, Young people should avoid applying for jobs which require security clearance checks during that access period and avoid travel where they could become flagged as criminal offenders in that other country. This is most common in the United States. Um, So you want to make sure that the access period has passed, because I'm not sure exactly what the RCMP share at customs, but they could do a criminal record check, find that you have a criminal matter, and then flag you. So even though your record gets sealed, the American system, for instance, would have a flag stating that you have a criminal record, even though they can't search for it anymore. So just be cognizant that criminal records can have a problem with teens in the future. If you need to get a criminal record check to see if it's still there, I strongly recommend that you do that. You can go to the police station in Edmonton, it's on the West End, submit your fingerprints, get the record check done. If it's still there, even after the access period, then you can contact us and we will assist in sending a politely worded letter to the police that they need to remove that from their system. So Kathleen?
So at the very beginning of this talk, we talked about how parents might turn to the police to help them in parenting their child who's making not the best decisions. But the justice system is not the only way to get help for your child. Where it comes in a situation where your child may be using illicit substances and is building an addiction to those substances, There are other ways to deal with those issues rather than turning to the police directly. This next slide talks about other options, including referrals to the family court system to get an order under the Protection of Children Abusing Drugs legislation to put your kids into a 10-day detox to hopefully try how to make better choices. There's phone calls that you can make to the mental health crisis line at the toll-free number or the 780 number listed there. Child and Family Services also offers assistance to parents without being actively involved as the guardian. Sometimes parents might just need a little bit more help getting referrals to various programs and community resources. So reaching out to Child and Family Services is one way to get that help, whether it be informally, just asking questions of a caseworker, or getting more involved through an enhancement agreement or a counseling support agreement with Child and Family Services in order to access those additional resources that you may not be able to access on your own. The last line, calling 211, is also a further source of resources for parents wondering what they can do next.
And unfortunately, the numbers that I put up here are the Edmonton numbers, not the Calgary numbers, but you could certainly do your Google search to find Calgary or other areas as well.
And speaking of Google searches, Legal Aid has a very handy summary page on our website and our support services that links to a lot of the resources province-wide that you can access. So when in doubt, if you're not in the mood for searching on Google, visit Legal Aid's website, and we have a listing of various links to stakeholders and other resources in various communities around the province.
So how do we keep my teen out of trouble? Well, I think first and foremost is never underestimate the power of peer pressure. You need to learn who your teen is spending time with. Um, and, during COVID, when young people weren't allowed to socialize, they often turned to Snapchat as well. And you need to know exactly who it is that they're snapping with. These may be individuals that they've never met before. And you need to be cognizant that those people could be getting your teen to do things they wouldn't normally do, such as sneaking out of the house, maybe getting involved with drugs or with crime themselves. You need to keep teens busy. Teens who are active in pro-social activities are less likely to commit crime. So find their passion and foster it. Your teens that are involved in soccer or basketball, or maybe they're into music or art, those things tend to keep young people out of trouble. Um, Young people that have more time on their hands are more likely to get into trouble. Now, I want to speak to you about teens and sexual boundaries and consent. Uh, Young people often get taught sex education in schools, but I don't think they're taught very much about sexual boundaries and consent. So there are certain exceptions to consent. So the age of consent in Canada is 16 years of age. However, if you are younger than 16 years of age, you can engage in sexual activities with people that are older than you. So if the child is 12 or 13 years old, it is okay for them to have sexual relationships with somebody as long as they are less than 2 years older than themselves. So you need to speak to your teens if they're dating somebody younger to make sure that the person that they're dating is under those 2 years. And that goes from the date of one person's birthday to another. So if, let's say, you have a daughter who is 13 years old and her boyfriend is 15 years old, well, the 13-year-old could be, freshly turned 13, and the 15-year-old could be a stale 15-year-old, in which case that boy would be committing a crime. It would be called statutory sexual assault. If the teen is 14 or 15, that age gap then expands to 5 years. So it's permissible for a 15-year-old to be involved with, let's say, a 19-year-old. Now, with the issues of consent, consent means getting an actual yes. I know we watch in movies where people lean in for the kiss and they seem to, they both seem to enjoy it. However, you do need to speak to your teens that they need to ask for consent each time. May I kiss you? Yes. May I grab something? Yes. May we have intercourse? Yes. They actually have to ask those questions. Now, that's not to say there can't be acts or gestures that mean yes, but oftentimes it is the boy who is going to be charged. So it is important that there's never a misunderstanding and that they give their proper consent. And they know that when they're told no, they don't get to try again later without asking again for that consent. The other thing we need to talk about is sexting. Sexting is when you write sexual words or phrases or pictures to another person. Now, amongst teens between themselves, that's not caught by this, as long as the images are deleted. So if you get a saucy picture, it's okay to look at it, but then you should promptly delete it. The problem that kids get into is when they try to show those pictures to their friends. Even if they're not sending it on, even if they're just showing it, that is still distributing or sharing child pornography, and that is against the law. And you should tell your children that, once they send an image out, it could be on the web forever. I know that Snapchat has a mechanism where images disappear. However, there's other ways to save it. You can screenshot it, and yes, when you screenshot, the other person is notified that you've done so. But, a lot of us have other cell phones or cameras, and there's nothing stopping that person from taking a picture from that phone and then uploading it onto the internet, in which case your teen will have that image there forever. So I think that is the end of our webinar, subject to any questions.
Perfect. Thanks, guys. And again, just a reminder for folks on how you can ask questions. So I see a hand up from Kate. So again, Kate, we suggest use the Q&A feature at the top of your Teams window. There's the example on screen that kind of walks you through the process. Where the button is, if you're on mobile, you do need to click the little dot 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 symbol, and then from there you'll be able to select the Q&A button. Just while we're waiting, I did just want to make just a quick correction on one of the items, Karen. I think just in order for legal aid to appoint a lawyer, the youth actually must be first charged. So I believe you had mentioned that they can call legal aid to receive legal advice. Currently, in order for legal aid to potentially provide a lawyer for the youth to be able to deal with, the youth does have to be charged by the police. So essentially, as soon as the charge has been laid and the youth's been given a court appearance or has been notified of the charge, they can call us at the 1-866-845-3425 number to apply. So we did just want to make, sorry, that quick distinction from our contact center team. So we had just a straightforward questions. How old does a youth have to be in order for them to be charged in Canada? What's the age cutoff?
The age starts at the stroke of their 12th birthday. The moment they turn 12, stroke of midnight, they are eligible to be charged, and they become an adult. Same thing when the stroke of 18.
Okay, thank you. We had a question for someone. Are there any specific legal responsibilities or obligations that parents have when their child is involved in a criminal case in Canada?
Typically, when a young person is charged the criminal offense, they have to give something called a notice to parent or guardian. It should go to the actual parent. In rare instances, though, it may go to maybe an adult that happened to be nearby when they were arrested. That notice to parent tells them of the court date and advises the parent that they need to appear. Um, the parent should appear for the first appearance, although if you happen to have a lawyer ahead of time, you can speak to that lawyer, and that lawyer can let the court know that the parent is in fact aware of the charge. Other ways to support your teen, though, is if they're being interviewed, again, make sure you're there. If you are brought into the interview, you make sure that your child does not say anything at all. The only thing that the must tell the police is their name, their age, their date of birth, where they live, those kinds of things. But any other questions is off limits, and it's up to the parent to step in. because sometimes the young person gets very confused. They get relaxed when the police officer starts asking questions like, what do you think of Taylor Swift? Or how about them Oilers? And they tend to soften the young person up so they start answering questions. So if the police start asking, how about that weather type questions, you still shut it down. That's the parent's responsibility to support their child.
Okay, thank you. I see we just had a follow-up question, just clarifying. So if a child is being investigated and brackets not charged yet, can they contact legal aid for advice? So I think the distinction is if the youth is being actively held in the police station, then they're able to contact the dedicated number. Is that correct, Karen?
If it's at the stage where they're actually at the police station and that number is posted by the police, and that is the number they call. And of course, there's 24-hour service. There's one of us on call any given day of the week.
Perfect, thank you. We had a question, someone was asking about extrajudicial sanctions. They're just wondering if you could provide a bit more information if those are used in youth cases as well, or like what are extrajudicial sanctions, just for folks that might not be aware, and
Okay.
then what should we know about them?
So in the adult system, we call it alternative measures. In the youth system, it's called extrajudicial sanctions, and it's pretty much the same thing. The broader scope is called extrajudicial measures. So it is possible for a young person to be arrested by police and engage in a different program. Calgary has a version, Edmonton has a version, and they go immediately into that without ever getting a court date. But when we see it, it's commonly when they come to court. If it's very minor, like shoplifting a pack of gum or something, you might get something called a caution letter, which is part of extrajudicial measures. And a caution letter is handed to the young person and to the parent. And it basically says, you were naughty. We can prove you were naughty. But basically, you're not worth the justice system's time to further prosecute you. And then the Crown withdraws the charge. The next step up, though, is what we call extrajudicial sanctions, where they would meet with a probation officer or a justice committee. Either of them would speak to the young person about their involvement in it, and they would sign a contract agreeing to do certain things. And like I said before, it could be community service hours, it could be writing an apology letter, posters, journaling, it could be any number of things. As long as they provide proof to the probation officer that they've completed it, they will then send an email to the Crown and the prosecution will withdraw the charge at the next court date. And it usually takes about 4 months from beginning to end to complete the extrajudicial sanctions program.
One of the things about the extrajudicial sanctions program as well is it's sometimes confused with young persons wanting to plead guilty to a criminal charge. And so just to clarify that by participating in the extrajudicial sanctions program is available to a young person, that is not a formal guilty plea. And so you will not be getting a criminal record for participating in the program. You may not be able to do the program in the future, but it will not be a record itself.
Yes.
Okay, thank you. We had a question from Kenneth just asking if you can explain a little bit more about the access period. So that might be tied to and Kenneth, you can add to your question if you want, but is that tied to the record?
Yeah, that would be tied to the criminal record. So the access period, there's different access periods depending on what the sentence or the outcome is. So for instance, if the charge is withdrawn, it's a period of 2 months. The young person gets a reprimand, which is a finding of guilt, but the record only lasts for 2 months. Then the access period expires. The most common thing is community service hours or probation orders. And the 3 to 5 years starts at the end of the sentence. So if you have a 17-year-old boy who pleads guilty and sentenced on his 17th birthday for 1 year, then that access period doesn't start counting until that year is up. So 3 to 5 years from when he turns 18. There is something called a conditional discharge. That is also 3 years. And unlike probation, the access period actually starts at the date of sentencing, not when the period is up on the conditional discharge. So I hope that answered the question.
Perfect, thank you. And I just want to give a reminder, again, unfortunately, due to the setup here, we're not able to answer questions live. So for those who have their hands up, we did also just enable the chat in case you're having any issues with the Q&A feature in Teams. You can also send us any questions as well through email. So I'm just going to type our email into the chat here. So I see Carol's asked a question. Are there programs to avoid criminal activity? So I guess it's more from your guys' experience. Do you know of any in the major cities that potentially parents can refer teens to or that can look into?
Well, in
There's not
Edmonton, oh, sorry, go ahead, Kathleen.
there's not really a don't do crime program in Calgary per se. As Karen had mentioned before, whatever interest your young person might have, that is something that you want to foster and encourage. Um, there are programs that are offered in the various cities in the province that talk about what happens to the victims of crime to educate people on empathy and learning what the consequences of those choices are. But at least in Calgary, I don't recall there being any like don't do crime, do this program instead option.
Yeah, no, Kathleen's right about that. And in Edmonton, there is something similar where the young person may have come in contact with the police multiple times, may or may not have been charged. So we have something called Y50. It's a police service thing where they kind of send out a police mentor. Um, and the Y50 stands for basically the top 50 most prolific criminal youths in the city. Although I guess crime is down or something because they seem to be expanding that and getting young people to have very minor charges. There's also another program called 180, and that's also another intervention program that the EPS also offer, where they see particularly very young teens, like 13-year-olds or 12-year-olds, that they may or may not get charged with a crime, but they seem to always get caught with people with horrific records or something like that. And so the police will step in. But there is no program that I know of that parents can simply access for high risk youth that could get them out of that mess. I think, as Kathleen's had suggested, there are other things that you can do, like getting your child involved in sports or other extracurricular activities where they could have more positive peers in their group and something else to focus on than being bored and spray painting things.
Yeah, thanks. We had a question just asking whether the courts are aware and have an understanding of autism or other potential mental health difficulties or challenges, and how potentially does that relate to the court system for youths?
Well, we're all very well aware that young people can have different challenges. Um, we do see some autistic young people, some with Asperger's. That seemed to be a fairly common one. We also have a program called the Alberta Health Services Diversion Program. It looks a lot like extrajudicial sanctions, but instead of doing community service hours, the focus is on following through on mental health treatments or counseling. So if the young person is charged with a crime, they could go through that process. And if they are successful in that process, they may have the charge withdrawn as well. Um, the Youth Criminal Justice Act is very individualized to each young person. So, uh, for instance, a sentencing judge or a bail judge will always be looking at what's the root of the criminal activity and how they can deal with it. So, mental health concerns are always at the forefront in most people's minds. And in the risk factors that we had listed earlier, we had referred to fetal alcohol spectrum disorder, which can manifest itself in many, many different ways. In some ways, it's cognitive. In some ways, it's impulsiveness. In some ways, they could display facial features that are indicative of fetal alcohol spectrum disorder. But even when they have the facial features, none of the other cognitive things are a problem. So yes, the criminal justice system is well aware of different diagnoses that young people commonly have, and they do tailor their decisions with respect to whatever it is that the young person suffers from.
Thank you. We have the question, what determines a young person being charged as an adult in offense if they committed it while he's a young person? You kind of hear that a lot. Sometimes they can choose to be treated as an adult or as a youth. Who makes that decision and what kind of factors are taken into account?
Well, first of all, the young person has to be at least 14 years of age. So 12 and 13-year-olds are not going to be looking at the adult sentences. The other thing that they would look at is what would the sentence be for an adult? I believe if it's 14 years or more for an adult, that's when the Crown could make that request. I have not seen anything short of manslaughter, murder, aggravated sexual assault, um, being chosen to go after them for an adult sentence. Although I did have one young person that had a string of bank robberies, in which case they were looking at an adult sentence. They didn't get it, but they were seeking an adult sentence. So, generally speaking, you don't need to worry about adult sentences. It's only if the young person is 14, and if an adult could get 14 years or more, could the Crown then make that application?
Yeah, thank you. I see we had a question from the Q&A. I'm just reading here. They just make the comment that Indigenous youth are overrepresented in both child welfare and the youth justice system. And then just asking if either you're able to speak to the role of child welfare as guardians in supporting the rights of youth.
Well, the criminal justice system is very aware of GLADU factors, and it is specifically written into the Criminal Justice Act. Yeah. So we did definitely are cognizant that there is an overrepresentation of Indigenous youth in both children's services and the criminal justice system. And I would also further add that being in the children's services system is a direct pipeline into the criminal justice system. Quite often, our first-time offenders commit offenses while in group homes, either destroying the property at the group home or an assault or a threat of some sort. And I'm sorry, why? What was the second part of the question?
We'll just asking if either you can comment or speak to the role of child welfare as guardians in supporting the rights of youth that may be involved in the criminal justice system.
Well, hopefully there are social workers that are watching this right now, because when there isn't a parent involved, then the social worker is the one that has to step in. I have attended at police stations when a young person is being charged with murder. They are in the care of children's services. Their caseworker is there. And I explain everything to the caseworker as I would to a parent and expect that that social worker would take on the role of the parent and specifically protect the young person's rights.
Okay. Uh, we have the question, if a 15-year-old was charged with assault and given probate and given conditional probation as attending sorry, one second, I just need to reread. So if a 15-year-old was charged with an assault and given probation as their sentence, is attending school regularly part of the condition of the probation? Um,
It could be, depending upon the judge imposing the sentence. With probation orders, the focus is more upon tying the conditions to the actual offense a young person is being found guilty of. So if school is tied to that, you might see that condition being imposed. Legally, outside of the justice system, young persons are required to attend school until they turn 16. So often, many judges will not impose that condition if the young person being sentenced is under the age of 16, knowing that they legally have to go to school. Um, some judges will impose that condition if they feel that school will help the young person change their direction and perhaps offer them more things to do during the day. But the focus of any sentence should always be tying back to the offense you're being found guilty of and being sentenced to, and the conditions should support addressing those factors that led you into the criminal justice system in the first place.
Thank you. So we have about 9 minutes left. So again, we'll give another call for any kind of further questions in the next little bit. I did see we had a question here. So we had talked about potentially with sexting or with sharing of private images. Are either of you guys aware of any either support, or where can someone go that may be a victim of such an offense can turn to? Is there any type of support in the city or agencies that you guys are aware of?
For
For
the victims
For
themselves?
rights for the victim. So someone that's had like a photo of them shared at their school, for example.
Well, by default, if there's been a complaint filed with the police, there are victim services, support people that work with victims of crime to support them through the justice process. Beyond that, for offenses that someone's a victim of a sexual related offense, there is the Luna Center here in Calgary that also offers supports to victims of that category of crime.
Okay, thank you. And we just had a question, kind of going back towards providing when a youth is contacted by the police. They're just asking for confirmation. So the guidance would be that the youth don't share any information with the police and in advance of being charged. And if the police charge, so be it. Just to confirm.
Yeah, like
Yeah.
Karen's summary of just name, contact information, date of birth, just the bare basics is the bare minimum. And beyond that, uh, they're not required to find anything further.
And sometimes I did have one instance of actually the young person had just turned 18, but he was charged with the youth sexual assault. Again, meeting on Snapchat, which is the youth Tinder. Um, the complainant only knew the race of the person and didn't know the full name. So she had done her own research on Facebook and she thinks this might be the guy. So the police contacted him and came in. And they didn't ask him any other questions except for, do you know who we're talking about? When they mentioned the girl's name, he didn't say a word. He just nodded. And that was enough to charge him. Without that nod, they would not have had anything. So it's very important that the young person say nothing, not to say where he was, who he was with, and that gestures like nodding or shaking your head is the same as a verbal answer.
Thank you. I don't see any other questions right here, but we'll give another minute or two, and then we can look at wrapping up today's webinar. But again, if anyone has any last minute questions, feel free to either type them in the chat, or you can also use the Q&A feature at the top of your Teams window. We'll give about one more minute, and if there's no other questions, then we'll just start with our wrap up. And just actually while we're waiting for any questions, I am also going to drop a link in chat to the survey. So as mentioned, we do look for feedback from our participants and the attendees. Just, share your feedback about today's session, and then as well provide us topics for other webinars that you'd be interested in attending. I see Karen's dropped a link. Perfect. So as some of you may have seen, it is Legal Aid's 50th anniversary this year. So there's a link that I'll drop in chat in a few moments for Legal Aid Alberta's commemorative website. You can go to the website to explore how legal aid services have evolved since our humble beginnings back in 1973 to the current work we're doing breaking down barriers within an adversarial justice system. You can learn about our ongoing efforts to make legal aid services more efficient and accessible for all Albertans. And I'm just going to drop a link into the chat here, so just make sure. Oh, I see Kate's asked a question here. So Kate had asked, if a young person has a concern about the conditions of their bail release or conditions of their sentence, can this be reviewed with the assistance of counsel?
Yes, it can. Bail is much easier to change. Typically, we just speak to the Crown prosecutor and get their consent to change it. If the prosecutor refuses, then we would have to go up to a higher court, which would be the Court of King's Bench. And I think it's Section 59 of the Youth Criminal Justice Act that allows you to request a change in a condition on a probation order as well. That takes a little bit more effort, but you fill out the paperwork. They will provide you with a court date, and that information gets passed on to the prosecutor. Typically, you need to be in front of the judge that actually sentenced you, unless it's something that the Crown is consenting to, in which case you can pick any judge you like.
Okay, perfect. Thank you guys. And so I see someone asked about the email. So if anyone has questions, To follow up about either Legal Aid's website or services, you can always reach out to us at communications@legalaid.ab.ca. So if you have any other feedback in the webinar that's not captured in the survey, you're welcome to send us an email. And I'm just dropping the link into chat here. And as you saw, I also dropped the link for our 50th commemorative website. You can also find the links to sign up to the 2 remaining webinars we have in celebration of our 50th. So attending the webinar, Vital Role of Duty Counsel in Our Justice System on October 25th, you can learn about the important work Duty Counsel provides in Alberta and learn how they help protect your rights when you make your court appearances. And then on November 15th, we have a webinar, Family Violence and the Emergency Protection Order. Attendees that attend the program or the webinar will be able to learn how they might be able to help someone that's experiencing family violence and the different protection orders that would be available for those folks. And with that, I'm just going to do one last check here. And perfect. And I see Karen's put it on our website as well. You're also welcome to check out our website. We do have a help center where you can go through to ask questions about how do you apply for legal aid? Is legal aid free? A lot of the items that we've touched upon here today. And I want to give a big thank you to our Karen and Kathleen for taking the time today to share their knowledge and their expertise. And also we want to thank you guys for attending. And we hope to see you at the next upcoming sessions later in October and in November.